morning. My name is P.E. Azubike, and I will be talking to you today on customary laws. Now, before I talk about customary laws, if you have not subscribed to this YouTube channel, please do well to subscribe. Now, customary laws. What is customary laws? Customary laws are a group of laws which are gotten from different customs, traditions, and different customs traditions which must pass through the validity test. Now, before we talk about customary law, it is important or imperative to note that customary laws emanate from people's customs and tradition. First, what is customs? Customs or culture are the various means of social behavior or the various people's way of life. Generally, in secondary school, we are taught that culture is the people's way of life, which is good. Now, culture is simply the way of life of the people, while customs includes the way of life, the belief of the people, and the social behavior of the people. Now, there are characteristics of customs. One of the characteristics is that one, custom differs from one place to another. That is to say, the custom of Ibeku might not be the same custom of Delta State. The custom of Abia State might not be that's places in Abia State might not be the same in places in the north. That is why custom differs from one place to another. The number two thing, or very important thing, is that custom is where we say it differs, and two, it changes from time to time. Now, because of the relative nature of the society and because the society keeps growing, that is why custom also keeps growing. Now, because of time, and I will go straight to customary laws. Now, customary laws, don't forget, are customs, but before they become custom, they must pass through the three validity tests. What are these three validity tests? One is the repugnancy test. Repugnancy test simply means that any custom that is repugnant to natural justice, equity, and good conscience is not custom. Now, what is natural justice, equity, and good conscience? Natural justice simply means what is naturally just, what is fair, what is right. Now, equity means what is equitable, what is equal, and what is just. Why good conscience means something that is just right. Now, any custom that is repugnant to natural justice, equity, and good conscience cannot be a customary law or law. Now, example of that is, let's say, the killing of twins. Naturally, we know that the killing of twins was a custom that was stopped by Mary Slessor. Let's say that custom is still in place and the custom wants to become a customary law. Now, the question becomes, in the validity test, the repugnancy test, can it pass that test? The repugnancy test says once it's repugnant to natural justice, once it's repugnant to equity, and once it's repugnant to good conscience. Now, is it good naturally to kill somebody? Is it just to kill people just because they are twins? Is it equitable? When you ask yourself this question, you will know it is not. We have the case of Mojuko versus Mojuko. We have the case of Edet versus Essien, and other various cases where the Supreme Court has said that once in parentheses, once that custom is repugnant to natural justice, equity, and good conscience, that custom cannot, shall not, and will not hold. Now, the second one is the incompatibility test. The incompatibility test says that any law that is any custom that is incompatible with the already existing laws of the land cannot become law. Now, Section 36 of the Constitution talks about fair hearing. So when there is any custom that contravenes that section 36, automatically it is incompatible with the laws of the land. Now, there are still laws of the land like the Constitution that says right to discrimination. We have Ukeje versus Ukeje. In Ukeje versus Ukeje, where they said that a lady or a female counterpart in the family is not expected to inherit anything. But the court said no, that custom is first, it's repugnant to natural justice, equity, and good conscience, and also it is incompatible with already existing laws of the land. And some of those laws include the right to against discrimination and what have you. Now, the last one is public policy. Now, it is important to know that any law that is against public policy cannot be law, or any custom rather that is against public policy cannot be law. Now, the question becomes, what is public policy? Now, truth be said, public policy is relative. How is it relative? It differs from one place to another. Don't forget, we said that custom differs from one place to another. Now, let's say in my place that it's against public policy to fornicate in public, to have sex in public. Now, when there is a custom that will be against that public policy, well, maybe a custom says you can go to anywhere and have sex and all that, automatically that policy is against public policy, and once it does that, it cannot go. Now, there are various ways of proving customs. One is by oral tradition, two is by written record, three is by court, and another instrument for proving customary law is evidence act. Now, with all this, we wrap it up by saying that custom can only become law when it passes the three validity tests. Thank you very much. I think we have been able to categorically tell you now. But before we close, I will tell you the characteristics of customary law. One of the characteristics is that, one, it differs from one place to another. Don't forget, we said custom differs from one place to another. That is how those customary laws differs from one place to another. Number two is that it must pass through the three validity tests. What did we tell you is the three validity test? The repugnancy test, the public policy test, and the incompatibility test. And then finally, which is also another important one, is mostly unwritten, although some states like Lagos have unified or written their customary law, but customary law generally are mostly unwritten. So that is that for customary law. Thank you, and subscribe to get more notification from our old video. Your mind is my warehouse. Thank you.